proceedings were awesome. We were given the opportunity, and that's what it was. Well, their first morning, I understand is going to get another night of party. And I think I can say he has no qualms that will get justice. And that is what brought us here. And I also think, and I believe the petitioner will also get justice. Equally, the second and only.
Yes, we can take a liberal view of affidavits, not those which will not comply with the law. Officer and her oath. Counsel contended that the oath had been properly taken, that the witness was at liberty to take the oath that they want. They could just raise up an arm, all sorts of things that might be said. It is our submission, my Lord, that submission was legally baseless. Why? Because Section 5 of the Oaths Act tells you how you conduct an oath. Section 5. And my Lord, what the witnesses have been doing in court here is what Section 5 of the Oaths Act tells you to do. You come here, state your faith, you hold the Bible, Quran, and then take the oath by repeating the words in the law. My Lord, the witness was unable to explain whether that happened during the process of examination. And my Lord, taking an oath is a very simple thing, by the way. It's something that the witness cannot forget. Something that the witness, if they did it, they cannot forget it. I cannot ask about a book and you are gas if you took the oath. Again, my Lord, my colleagues asked you to take a liberal view of that affidavit. I repeat my submission that the liberal view can only be taken where the affidavit complies with the law. This one does not. We also thought, my Lord, on this issue that counsel misunderstood our complaint. We did not say, my Lord, that the evidence given by the witness Viva Voce in court be expunged. No. Because when she came here, she took proper oath and gave witness during her cross-examination. We did not touch that evidence. We only touched the evidence in the affidavit, whose oath had nothing to do with the oath in court. And my Lord, from the decision they gave you yesterday, themselves, of Mugema Peter, thankfully, those two pieces of evidence can be separated from the decision of Mugema they gave you yesterday. And the part I'm referring to is the very part they highlighted. So I'm only asking the court to separate the affidavit from the evidence that she gave in court. In court, I have no problem. I have a problem with the oath that she took or purportedly took in that affidavit. My Lord, I move to issue 1. Issue 1, when counsel was submitting, she stated that we did not ask to cross-examine Ben Asante. Of course, that was not correct, because we did, and the court made its decision. I do not want to go back to it. Second, she stated that we still were referring to the expunged affidavits. My Lord, that was also a misunderstanding on her part. The evidence that we referred to was that they gave on the stand, nothing to do with the expunged affidavits. We did not refer to it. And my Lord, again, from the Mudiowole decision, that evidence is separate. Throughout my submission, I did not refer. And I know my Lord asking me which evidence I referred to, and I replied that which they gave at the stand, not the expunged evidence. Thirdly, on that issue, briefly joined again on that issue, counsel attempted the argument that by removing Ben Mukasa's affidavit, we are denying him a fair trial. My Lord, that at best is a strange argument. Why? Because Ben Mukasa, and the reason why we are impeaching his affidavit, is that he was the architect of the egregious circumstances under which affidavits were recanted. So now for him, now come and say, give me a fair trial that he deliberated, a fair trial that he did not believe in, and that he sought to frustrate. Had he not been gotten in his tracks, he would have frustrated a fair trial. That is the one that he wants to participate in. My Lord, we are saying you should not allow him. The evidence we got was that we destroyed electoral materials. Yes. From my knowledge of them, they are not linked to safety, sir. From my personal knowledge. But from my personal, they don't send anywhere. They are station by station. We have not reached that level of technology. On the issue of the formula, established substantial items, I was touched on it fairly briefly. Let me, my Lord, restate that formula. That formula is, if you want to find out whether the election was affected substantially, what you do is to look at the margin between the winner and the runner. Vis-a-vis the number of voters whose electoral choice was not considered in the final tally. As simple as that. My Lord, that formula has been given in the numerous decisions I have given. And permit me to say this, my Lord, also. There is nothing in any of the vested decisions that Mr. Remy went on and about that says you don't apply that formula. And my Lord, in the decisions I've given you, for example, Antiti decision, they first quoted Mulenga in one of the vested decisions, and then they applied that formula. That's how their lordships in the Court of Appeal understand there's no confusion between the BCJ decisions and the Court of Appeal decisions, as my learned friend Mr. Remy appeared to suggest. There's no confusion at all, and they should be done. Then some of us also try to touch on the issue of qualitative versus quantitative standards when determining substantiality of the election. Right from day one, we are talking numbers. So I thought that one should also be clarified. And the authorities were given you on numbers, not quantity. You also faulted our witnesses. Why didn't you keep a voter turnout? Why didn't you keep where you scribbled that so many people had turned up? My Lord, need I restate that our witnesses told us those things were destroyed? The witness who came to the stand, my Lord, Omulamuzi Awa, was cross-examined on that particular point. She was asked, who was asking whether she had her own notebook, and she was clear it was destroyed. Moreover, my Lord, it is not the duty of agents to record voter turnout. That duty rests with the second respondent. Very briefly hinted, my Lord, on the issue of the decision in Wakaima. My Lord, that one permits me to go to that decision. Give me that page 831.
And I urge like his urging. He has convinced you in the last 4 years that actually you are not distinguishing. Now when it came to the presidential petition, he's raising the same argument. I don't know how the petition when it comes to you, you twist it. I think what is
let him first listen to the argument. I have just started it. I am going to tell you a lot of things about Christianity. First relax and listen. I will give you a right of Saawa Yonna. Now, my Lord, I was saying, therefore, those statements of the law are shaped by that standard. Now, it is not a correct approach, therefore, to pick those decisions wholesome. That's why you need to wait and see. You don't need to pick those decisions wholesome and apply them to parliamentary elections, because you may fall in error. Mr. Service, the Supreme Court itself has warned itself against wholesomely applying those decisions to parliamentary elections. The Supreme Court itself. Now, this is the case of Mukasa Anthony Harris. Mukasa Anthony Harris versus Supreme Court itself has made the decision. It's telling you, please go slow. When you come to this thing, say, this station has no page, but I'm going to give this. It's a new matter. It's not there. It's a new case. Let me read for you what the Lordship say in the Supreme Court. Learned Counsel relied on the reasoning of my learned brother Kakule JC in our decision in Kizabesi versus Museveni, for the view that the charge of bribery had to be proved beyond reasonable doubt and not on the basis of a balance of probabilities. Counsel concluded that the evidence adduced by the respondent did not establish the allegations of bribery or charge of bribery beyond reasonable doubt. Regarding the Court of Appeal, Mr. Barikude asserted that in the lead judgment, which other members of the panel concurred, the JA properly directed herself to the duty of the First Appellate Court, and that she properly evaluated evidence before she applied the findings of the trial, upheld the findings of the trial judge. Let the Lordship say this. I am not persuaded by the argument of learned counsel for the appellant. First of all, the learned judge properly directed himself when, after referring section 61.1 of the EEA, now it is the 81. He stated at paragraph 6 of the judgment, I will not read it, my Lord. Then he goes on, the Justice Supreme Court goes on this point, I am surprised by the assertions of learned counsel, the appellant, who unfairly criticized the two courts that they misdirected themselves on the standard of proof by applying the standard sanctioned by the statute, which is balance of probabilities. Learned counsel is certainly aware of the existence of 61.3, now it is 83, for he alludes to it at the end of his arguments. Throughout his submissions, appellant counsel relied on the opinion of my learned grantor, JSC, in his Avesti election petition, notwithstanding that the Presidential Election Petition the Presidential Elections Act does not in itself have a provision similar to 61.3 of the DEA, which